Okay, we're back. Hi, I'm Roger Royce. I'm a corporate partner with Haynes and Boone in Palo Alto. I work with startups, and I'm also the author of the 10,000 Startups book, Legal Strategies for Startup Success. And you are now joining our podcast on various legal issues for startup companies, things that you as a founder or as an investor want to pay attention to, watch out for, tips and strategies, where each week we're going to talk to somebody who can give you some very good practical advice on startup legal. And today we have Tom Moore, who is with Haynes and Boone in Palo Alto. He's practiced law in Palo Alto since 1984, representing individuals and startups all the way to mid-sized technology companies in intellectual property and commercial litigation matters. He's focused on getting results in as efficient a manner as possible, which is really important for a startup. Tom's a litigator, but he's handled matters in all four of the areas of intellectual property: patents, copyright, trademark, and trade secret, including complex license agreements. But he also does more than that. He does commercial litigation. He's handled breach of contract, breach of fiduciary duties, false advertising, and basically all aspects of the law of fraud. So I want to thank you for being here today, Tom. I always like to talk to litigators because they got such great war stories.
Thank you, Roger. We might describe today as strategies for startup failure, which is almost as which is something you need to know as well. Now, part of my background is that I have not only worked with some very talented litigators as mentors, but some very impressive corporate lawyers as well. So I have been sort of taught at the knee of Mario Rosati of the law firm Wilson Sonsini Goodrich and Rosati, and Tim Tomlinson of the law firm of Tomlinson Zisco. And so over the course of my career, I have handled dozens, probably, cases involving fiduciary duties in the corporate private company context. There are a lot of misconceptions out there as to what they are and how they apply. And so I thought I would set the record straight, and then get into some real world examples of how these things can get very complicated very quickly.
Oh.
So, good enough, Roger?
Okay, that's great. Let's kind of kick off with kind of one big question. It's kind of funny, many years ago, I'm not a litigator, but somehow I remember sitting in a arbitration listening to people talk about all the great planning that I had done. And the lawyer that was cross-examining my client, my client kept saying, well, I had to do this because of my fiduciary duties. And the lawyer said, tell me exactly what is a fiduciary duty? And he couldn't answer. So, so tell us, what is a fiduciary duty? Why are they important? Who has them?
Okay, let's break that down. What is a fiduciary duty? Well, it comes out of the law of trusts, and I describe them as basically when you have management or control over somebody else's money, the law applies an obligation on you to manage that money with the utmost good faith and fair dealing. So fundamentally, it is an obligation of good faith. Now, that being said, there are actually it breaks down into kind of high hurdle situations and low hurdle situations. High hurdle situations are where there's a conflict of interest. If there's a conflict of interest, then a court is going to scrutinize a transaction in minute detail and compare it to and deal with it in terms of an absolute sense of fairness. Low hurdle stuff is called the business judgment rule. And so if all things are equal, no conflicts of interest, then a member of the board of directors, what have you, is entitled to use their best business judgment after reasonable inquiry in terms of how a given issue is decided. So who has them? The members of the board of directors have them. The officers of a company have them, essentially the C-suite, and majority shareholders in certain circumstances also has them. Question answered?
Basically, but can you maybe give us a real world example? I mean, where it comes up, suppose a company is, contemplating doing a financing or
Yeah.
entering into an M&A deal or something like that.
Okay. Let's start with the financing. It depends with whom the financing takes place. If it is an existing investor and that existing investor sits on the board of directors, then there's a conflict of interest. And that director is going to show that that transaction complies with the duty of highest good faith and fair dealing in terms of the fairness of the price and the fairness to all the shareholders. Fiduciary duties apply to all shareholders. In other words, a board member, he or she, can't just look and say, well, it's fair to me, so it must be fair. And that's situations where it often makes sense to have a disinterested director in the mix, because the disinterested director who lacks a conflict of interest can exercise his reasonable business judgment. And if that's in the mix, then you're dealing with much more of a low hurdle situation.
Yeah. Can I stop you there for a second?
Sure.
Suppose we don't have a disinterested director, because I tend to just assume we're not going to find one because all the directors are under the thumb of somebody else
Sure.
that is interested. So let's suppose we don't have a disinterested director. You said then it has to be fair to the corporation. Whose burden of proof is that, and why is that a big deal?
Okay, the burden of proof is on the people who have the conflict, who are involved in the transaction. So this often comes up, particularly in the context of down rounds. And in that circumstance, if there's no disinterested director, then you need other tricks up your sleeve. Good reason for hiring Roger, by the way. One trick is to go to a consultant in order to get a fairness opinion of the price, and the consultant will look at other companies, and you can sustain or meet your burden of proof of having to prove fairness if an outsider is in a position to do it. The other way of handling the situation is to make the offer available to everybody, so that there are not any minority shareholders who, if the minority shareholder thinks that the price is too low, if they're given an opportunity to invest, then they need to take it because they're saying it's too low. So those are two of the ways of handling that particular situation.
Okay, and this can come up in a lot of different ways, can't it? Like compensation, stock grants,
Yes.
option grants,
All of those things.
all of those things, wherever you find any sort of economic conflict, right? Hiring your brother-in-law.
Hiring your brother-in-law, and that's an aspect of where, just to note the business judgment rule, you have to be careful with that. You need to make a reasonable inquiry. That's important. The other thing is you still need to avoid situations that are going to destroy the company. So appointing your brother-in-law, yeah, that's not good. Appointing your dog Fido as CEO, that doesn't even comply with the business judgment rule. So it's not like the low bar is so low that you automatically jump over it. So you have to be aware of all of those things. I have had situations come up. where in effect, it wasn't a brother-in-law, it was a son who was put in charge of a company, and he was woefully incompetent, and that can be a problem.
I'll bet. Well, let's shift gears a little bit, because I know you've kind of carved out a niche here for, and I've heard you say this many times, and what you call the fire of the founder case. Tell me a little bit about that. How does that come up? Why does it come up so often? And why is it always a big fight?
Okay. Fire of the founder is really an internecine battle inside a board of directors. And it can be, I call it fire of the founder because I'm naturally cynical, but it can be investor versus founder. Founder versus founder is very common. And why does it come up? Often it's a function, there are egos, control issues, and greed can create these situations sometimes. And I'm not going to say this is uncommon. The founder genuinely is not in a position to take the company forward. The skill set for being an entrepreneur and getting a startup going, and the skill set to manage a medium-sized company up to either acquisition or IPO, that's a different skill set, and so that's another reason that it comes up. These things are nasty. They burn hot, they burn bright, and they almost always settle. And fiduciary duties run throughout them because often there is there's some self-dealing involved. I mean, that's where the ego and greed often come into play. So a sort of situation I've seen is where an investor has a portfolio, 10 companies, 9 of them fail. So the investor goes, oh my gosh, I need to make extra money on this one that has yet to fail. And so what they want to do is, scrape over to themselves maybe a little bit more stock, maybe take control over the company, remove the CEO, remove the founder. And I've had that come up more than once. The most serious situation, a CEO came to me, said, it looks like my investor is going to fire me. And the reason they want to fire me is because they want to have a triple litigation preference. In other words, they want to invest $1 million, and if the company gets sold, they want $3 million back. The problem with that situation is that it wiped out the option pool. It put all the options of all the employees underwater. The CEO wanted to stop it. The CEO knew this was the plan, by the way, and real world situations are interesting because the administrator who was in charge of the email server was on her side. And so the administrator was reading the emails between the CFO, who was in cahoots with the investor, and the investor. So they had a term sheet that was not shared with the CEO or with the board, but she knew what was going on. They fired her, notwithstanding my kicking and screaming. All the employees quit because the stock options for which they were working were underwater. And including the administrator, who walked away with all the passwords to the server that had the source code on it, the source code that was under development. And of course, the investor thinks, okay, we'll have the software that will outsource it to Sri Lanka. What the investor did not know, and this is where reasonable inquiry gets into things. What the investor did not know is that the software engineers had only just started to develop the software. So there was literally nothing in the server. There was no company. So investor lost its full investment, CEO lost her job, everyone else lost their jobs. It was a complete lose-lose situation. And frankly, one of the great losses, one of the great tragedies of my career. It was a good company.
Yeah, that's too bad. I mean, we see that a lot as lawyers, where you find that startup that solved all the really hard problems, right? They've got product market fit, they've got a good technology, the customers love them. They might even have the right team in place, but then they make some silly legal mistake and they're all done. And
Exactly.
that really is sort of tragic, because it's so rare that they get all the business stuff to line up exactly right and just mess it up over something that's totally avoidable. Speaking of which, I mean, the one biggest thing I think I see on that count is founder disputes, where you got everything going the right way, but all of a sudden the founders then start fighting. And it might be because they haven't documented like their ownership, their vesting, their comp, whatever it is, whether the money they put in comes out as a loan or whatever. I know you've got quite a bit of experience in founder disputes. What can you tell us about that, and especially how to avoid it?
How to avoid it?
Yeah.
I'm not sure I know how to avoid it. Let me start with an example, and we'll get to how to avoid it. I had a chief technology officer walk in. He said that he was about to get fired by the CEO and by the board. He had developed the technology. The technology was subject to a patent application. His stock had not yet fully vested. The CEO wanted to be listed as an inventor on the patent application. And the CTO said, I cannot list a person as an investor, as an inventor, who didn't invent any aspect of this. If I were to do that, it would be a fraud on the Patent and Trademark Office, and we'd lose the patent. So, so the CEO went to the board. Let me tell you, my CTO got fired. 4 weeks later, the board went back to my CEO, said, we just fired the CEO. How would you like to be the CEO? And actually, that's where that story ended. How to avoid it? Really, this gets down to Benjamin Franklin saying honesty is the best policy. Dysfunction is extremely harmful to a startup. Basically, find a group of people with whom you get along, develop mutual trust, because, as I said, ego, control issues, and greed tend to be the rocks that these startups end up hitting. And so on just a really basic personal level, you need to find a way to avoid this. The most successful entrepreneur that I've ever met, he was the founder of VeriSign. I don't know if he made $1 billion or not, but the stock price went to the founder's stock of 1/10 of a penny. And its maximum market share at one point was $10 billion. And he owned the biggest hunk of stock. He was generous, he rewarded his employees. He made sure everyone was on board. And he was a hell of a nice guy. So
Yeah.
sometimes I know this sounds more like life lessons than legal lessons, but that's what you need. Now, do good foundation documents help? Yes, they do. It's one's leverage for negotiating severance is at its biggest when you first get employed. I've certainly had founders and CEOs come to me and say, well, there's no severance in my employment agreement. But you know, someone in my position, we get 8 months severance. And my reaction is, yes, you get 8 months severance, but only if you negotiated at the beginning of the employment. At the end of the employment, when your leverage is gone, if I can get you 3 months, you're way ahead of the game. And sometimes I can.
You know, that's an interesting point you make about the document. So as a litigator, I mean, typically, you know, a startup entrepreneur doesn't want to see you because that means something's gone wrong.
Yes.
And there's a fight somewhere. And when that happens, because businessmen, I find, you know, sometimes think that a lot of these formalities that I insist they follow are a little silly. Like, why do we have to have that in writing? Why does it have to say whereas at the beginning? Why do we have to recite that we properly gave notice and nobody objected and all of this stuff? But you tell me, Tom, as a litigator, how important are these documents and how important are these formalities?
I cannot emphasize how important they are. So given a dispute that goes to court, you have a judge. Now, that judge might or might not have business law experience. Most judges are former district attorneys in state court, and they're former personal injury lawyers. They have two sides who orally say different things. You know, I thought this, I thought that, that was my understanding. The documents speak loudest of all. And one thing that people don't always understand about jury trials, you know, a jury sits there and they listen to the people on the witness stand. And one witness says one thing, another witness says something else. But these documents, they are exhibits. Those documents go into the jury room during deliberations. The testimony does not. So a document with a signature on it is huge. It just can't be. I have seen many disputes, and when the judge or a jury rules, it really comes down to what was said in the documents. So there you are. Handshake deals and the like. It was the movie producer Samuel Goldwyn who said that an oral contract is not worth the paper it's written on. and really truly, and those are more likely to go all the way to trial. Whereas if something's well documented, it can be a very short litigation, if it ever even gets into litigation. I have certainly confronted other parties, you know, through threatening a lawsuit. You know, take a look at the pieces of paper, and then the dispute ends.
Okay. Well, can you give our audience some advice as to how to avoid having to deal with litigators going forward?
Yes. It's what I call the 10-to-1 rule.
Okay.
By putting your founding documents in writing, by doing it correctly, or when a problem arises and you need, and you can see that it will be contentious, go to the corporate lawyer, go to Roger. If Roger needs me, Roger can find me down the hall. But it's better done that way, because you can spend $1,000, $2,000 on Roger, because if things escalate to where you have to retain me, the ratio is 10 to 1. So if you could have spent $1,000 on Roger, you will spend 10,000 on me. If it's a situation for $5,000 for Roger, it will be $50,000 on me. And I have seen this. This is real experience, and on what the ratio actually is. So my advice is, lawyer early and often, and because I actually, as a fan of startups, I prefer not to get used. Now, I'm very proud that I have lost maybe 8 startups in litigation after having represented dozens, but still, it's always dicey. It's always dicey, and it's a distraction.
Yeah, that's for sure. And sometimes a company killer, isn't it?
Yes, it can be a company killer. You take your eye off the ball when what you should be doing, and then suddenly another company pops up and disrupts everything. Things move too quickly in technology to be distracted by this kind of stuff.
Let me ask you one last question. What is the most common mistake that you see startups make that causes them to end up on your desk? Just the one biggest thing.
When you put together articles and bylaws, follow them. Go back and read them, see what it says you're supposed to do. It really, that tends to be, that's where the dispute starts. If there's a disconnect between the governing documents and what somebody wants to do, then things tend to escalate quickly. As an example, if your founding documents say 5 members on the board of directors, get 5 members on the board of directors. So this is a funny situation that I've had up. 5 members were authorized. Only 3 were appointed. Well, your quorum with a 5-member board is 3. So if one person doesn't show up, you don't have a board meeting, and they can refuse. So it's that kind of thing. That kind of answers the question, but don't leave loose ends is part of what I mean to say.
Yeah. Okay, we got you. All right. Well, Tom, I want to thank you for being here today. Thanks for this valuable advice and those interesting war stories, I guess cautionary tales of
Yes.
what not to do and what to do. This is Roger Royce. This is the 10,000 Startups podcast, and we've been talking today with litigator Tom Moore. Thanks again, Tom.
Thank you, Roger. It's been a pleasure.